Okay, we're going to keep it moving, and I have Jeff Verdon with me today, who is he's an expert in estate planning, asset protection, and probably tax efficiency with your, with the estate planning and so forth. He had a firm, but he just recently partnered with, what is it, Berkman? What the hell is the name of that?
I'm going to tell the audience all about
He'll tell you all about it. So anyway,
Thank
there
you.
go, Jeff Verdon.
Thank you. I have a mic. Can you all hear me? This is my fourth presentation this week on this subject. My voice is a little going, so I apologize in advance. I'm Jim's estate lawyer. I've known Jim for a while. As he mentioned, my name is Jeff Verdon. I am a partner in the law firm Falcon, Rappaport Berkman. We're based out of New York. I run the Irvine, California office. And about 2 years ago, a little over 2 years, I merged my practice into Falcon because they've got a much bigger, robust group of lawyers, about 75 or 80 lawyers, and my clients, for whom I primarily do estate planning, needed these additional services. And quite frankly, my clients were starting to ask me, well, who's going to take over when you retire? And what they're really asking me is who's going to take over when I'm dead? So I'm not planning on retiring anytime soon. I feel great, vital, but I wanted to have a succession plan for my clients and my team. And so I'm with Falcon, Rappaport Berkman, and it's been a great ride. I chair the Asset Protection Planning Group. What that means is I work on the larger estates, the taxable estates for the clients in the firm, helping them mitigate their estate tax liability and also to protect their assets against those awful lawyers out there that are trying to. All right, let me try that. Is that better? Okay. So the risk that we look at when we sit down to do an estate plan, it's what I call the 40%, 100% risk profile. 40% death taxes, so you can work your entire life, build this beautiful estate to leave to your kids, and the government's going to take 40% of that estate above whatever the exemption is at the time that you pass away. But what's worse, and what keeps us up at night for our clients, is the litigation risk, because litigation attorneys can take 100% or more of your estate. And that's really what I want to spend a good part of my presentation talking about, which is something you never think about. It's going to be a little bit dark, ladies and gentlemen, my presentation in the beginning, so I apologize, but you need to know about this, because once the event happens that creates a liability, it's too late to do anything about it. The two pieces of advice I always give my clients, and things you should leave with, is fly first class or your kids will. And if you think I'm thinking about upping that to fly private or your kids will. I know many of you in this room are my age or older, and you think about saving your money and not being frivolous. But the reality is when you leave this earth and you leave your kids the money, if they can get to their destination in business or first class, they're going, and it's going to be with your money. So don't deprive yourself of the things that you want to and should take care of during your lifetime. Your kids are going to be fine. And the other piece of advice I give them is spend your kids' inheritance. And if you have too much money, then come see somebody like myself or other estate lawyers that can help you protect it. Okay? Now, I mentioned asset protection planning. When I started my career in the late 70s, about 6 or 7 years into my career, I was hired by some local doctors here in Newport Beach to do their estate plan. And these doctors were going to retire in 5 years, and they could not get malpractice insurance to cover them beyond 5 years post-retirement. Now, when an OBGYN retires, they're on the hook for that baby's liability until that child reaches the age of 18, plus the statute of limitations for malpractice, which means it took these doctors into their early 80s before they were out of the woods legally from a lawsuit. They had accumulated some assets, and they were looking to protect these assets, and so they asked me to do that. That was my task. Now, the problem was, we never learned about how to do this in my tax classes in law school or my graduate tax program. We worked on the problem of moving the wealth to the next generation, making our clients' kids and grandkids richer. But what we didn't focus on is what might happen if our clients get sued and they lose all or most of their wealth. So I dove into the subject matter I learned some techniques, and I put this into effect. And when I finished that process, this is 1985, I realized that maybe I ought to change the focus of my practice and begin to integrate with the estate planning work I was doing, asset protection, so if my clients got sued, they would not be a particularly attractive target for the plaintiff's lawyer, and they might go away or settle for pennies on a dollar, and the client would be able to maintain his legacy. And that's exactly what we did, and for the last 40 years, that's how I approach, and that's how I think about estate planning. Now, there's three fundamental principles that I think about when passing the legacy on to my clients, including the two I just told you: fly flat first class or your kids will, or spend your kids' inheritance, and if you can't, then do some estate planning. It's generally not what's in front of you that takes you down as far as a lawsuit. It's always something that comes out of left field. And so you need to prepare yourself for that. And your targets for lawsuits, if you have wealth, I mean, the reason why Willie Sutton robbed banks is because that's where the money is. The reason why rich people get sued is because that's where the money is. Plaintiffs' lawyers do not like to sue people who don't have money. And lastly, in the concept of your estate planning, wealthy people want to control their wealth. They just don't want to own it. If you don't own it, they can't take it from you. And I'll show you some techniques to go back to your current estate planning lawyers, if you have one, and talk to them about this. So what is asset protection plan? What is asset protection? It's simply changing the title to assets which you currently own and which would be vulnerable to a lawsuit if you happen to be sued. Or when you acquire new assets, take title of those assets into a different structure so that if you're personally sued, those assets aren't susceptible. Now, the statistics about litigation in this country are astounding. 95% of the world's lawsuits are filed in the United States. And if you want a copy of the slide presentation, we can arrange to get that through Jim's organization. But there's somewhere between 30 million and 100 million lawsuits filed in this country every year. That's an astounding amount. And so it's something that if you haven't been sued, it's probably statistically a matter of time until you are. But it's like the concept, when your insurance premium comes in for your auto insurance, and if you have a stellar driving record, you've never had an accident, no speeding tickets, but every year you send that check into the insurance company. Why do you do that? You do it not because you plan to get into a car accident. You do it in case you get into a car accident. It's the same thing with asset protection planning in your estate. It's in case you get sued, not because you plan to get sued. Now, why asset protection? For the very reason I've been talking about the last few minutes. You want to be able to preserve your legacy and pass it on to the next generation without the intervention of some lawyer coming in and taking it away from you. Now, California is a #3 jurisdiction for lawsuits in the country. You'd think it'd be #1 because California is a very suit-happy state. New York being #1, Florida being #2. But we are a very litigious state. Now, when I sit down with clients and I talk about this subject, most of you aren't really focused on this. You're not thinking about asset protection. So I put together this lawsuit exposure test, and you can go on the QR code and you can download it and take the test yourself. And if the individual scores on the higher end of the answer key, they should be thinking about doing planning to protect their assets because they're probably in the high risk category. It's not about what you own, it's not about what you do, it's about what you own. Let's say you're coming out of Ralph's one day and this homeless person comes up and wants some money, and you're not feeling particularly generous because you just spent about 40% more on groceries than you normally used to. And you get into an argument or a tussle with this individual and you get knocked down, they injure you, they damage your property, and you call up Larry H. Parker because you want to sue this person. As soon as the lawyer on the other end of the line hears that whom you want to sue is a homeless person, they're not going to take your case. Not because you don't have a good case, it's because there's no money to get at the end of the rainbow. So we want you to be kind of in that category when somebody potentially comes after you in a lawsuit that your assets are not particularly available. Now, if you ask any litigator, and I'm married to a litigator, my daughter's a litigator, my son's he's a lawyer, but he works for FEMA, he's not a litigator. They will tell you over 90% of lawsuits settle, and they settle for one of two reasons. Doubt as to liability or doubt as to collectability. In our firm, we're in the doubt as to collectability business. Now, we do not do planning for somebody who comes to see us after their hair catches on fire and now they're in a lawsuit or a claim. No, we don't do that. But for clients that are looking at prospective planning and want to get their assets out of harm's way, whether it's just the money in your bank, whether it's your portfolio, or whether it's your home, or or your real estate properties, we want to protect those assets against a future claim. Now, I often get asked the question, does asset protection planning really work? It depends how you define work. In my world, if you have a structure in place and there's a threat of a lawsuit and you can settle that lawsuit for less than the claim than had you not had it in place, then it has worked. And here are some examples in the years that I've been doing this, just a few, of clients of ours who have been sued, the red numbers being what they were sued for, and the green numbers are what they settled for. And there's a big disparity between the two. And the only reason these results were achieved is because the people on the other side of that lawsuit made a determination that it was better to settle than to litigate because of data's collectability. In litigation, the process is the punishment. So if we can keep you from going through the process, much less saving the money you'd have to lay out if you lost, then an asset protection plan geared to your estate planning or tied into your estate planning just makes a lot of sense. You can't defraud creditors if you do this kind of planning. So we have our clients sign an affidavit of solvency, and they're representing they're not planning on filing bankruptcy after they set up the plan. It's not lawful, it's not ethical, we can't do that. They're not insolvent after the plan. So we have to make sure that whatever steps you take to do asset protection planning, you do it properly and you do it legally. Very important concept that I don't think enough people give some thought to. There's two types of liability out there that can take you down. One is inside liability. Let's say you have a portfolio of rental properties. And many people, too many people, will take all of their rental properties and they'll put them in one LLC. And they do this because they want to save the money on creating a second LLC. They want to save the money of paying the $800 in the state of California. But let's look what happens. If property A gets into a lawsuit and property B, C, or D are in that same LLC, that judgment creditor who's suing the LLC entity has the choice of picking any one of those other properties to satisfy their judgment if you don't have enough liability insurance. And you might think, well, I have a lot of liability insurance. Well, I had a gentleman in my office last Friday who has several apartment buildings. Some bad people broke into the garage of his apartment building. Apparently the door was not properly locked. And when two tenants came home late at night, these two bad people robbed them and shot him. And now the individual that came to see me is a defendant in a $35 million lawsuit. He has a $2 million umbrella policy. So that's the problem with liability claims. You probably aren't carrying enough liability insurance to protect you if you have that, the big one, as it were. Excuse me. Outside liability is where you have assets that you own. You probably have a beautiful living trust. Your lawyer put in that nice red binder and handed it to you when he left his office. What the lawyer probably didn't tell you is if you get into an accident or a lawsuit after you leave his office, and your assets are in this revocable living trust, which was set up to avoid probate, that living trust is not going to protect one penny of the assets in your living trust. And so outside liability simply refers to a judgment creditor being able to take those assets should you get sued and they're not protected from those kinds of forces. Let me just spend a couple of minutes and go through some of the asset protection planning tools in our toolkit. How many of you still own a business or work in this room? Okay, a few of you. Well, the best asset protection strategy no one has ever heard of in California finds its genesis in CCP section 704.115. That's a statute that was enacted in 1970 in the state of California. And if you own a business, your business can set up what's called a private retirement plan. A private retirement plan, by definition, in the statute, is a plan that's established for retirement. It doesn't have to be a tax-qualified plan. It doesn't have to be an ERISA-qualified plan. It just needs to be a retirement plan. And you can fund assets into that plan. And according to the statute, when you fund your assets into the plan to provide for your subsequent retirement, once those assets go into the plan, they're 100% protected from lawsuits, future lawsuits, except in the case of alimony and child support. Number two, when you take the distributions out of your plan, from your private retirement plan, those distributions are completely protected from future lawsuits as long as you don't commingle it with non-exempt assets. So it's a very, very attractive way for somebody who's in their own business, who may not have enough money in their qualified plans and want to be able to protect some of their assets in a statutorily protected vehicle like the private retirement plan. Three important components when you think about setting one of these up. Number one, you have to do a feasibility analysis. How much can I put into my plan? And that's driven by economics, it's driven by your salary, it's driven by what you expect your future net worth to be. If you make $100,000 a year, but you want to put a $10 million asset into your private retirement plan, that's not going to work. There has to bear some relationship between the contributions to your plan and what your net worth and income will be in the future. And there's a software program that we use to determine that. Number two, the documents have to be created properly. You need a plan, you need a trust. And then you need a third-party plan administrator to administrate this, just like if you had a qualified plan. But once you do this and you fund your plan, you have excellent asset protection. There are two types of asset protection trusts that I want to mention. When I think about estate planning for clients, there are two verticals that we want to look at. The assets that you own, that you expect to appreciate in value, and you don't need for lifestyle, you want to move those into an irrevocable trust, move them out of your estate, so when you die, the value of those assets are not subject to the 40% estate tax I mentioned. But those are assets that you're not going to need, and therefore you put those away for your kids and grandkids. But the other portion of your vertical, these are the assets that you need to live on. These would be your securities, your potential rental real estate, bonds, other assets, your cash sitting in the bank. You want to take those assets and you want to put those in a bucket that do not allow your creditors to reach, future creditors to reach them if you happen to be in a lawsuit. That's called an asset protection trust. Now, California does not recognize asset protection trust. Only about 20 to 25 states have laws that allow that. So what you would think about doing is taking these assets that you want to protect for consumption and put it into an asset protection trust, so if something happens down the road, those assets can only be reached by you and not by your subsequent creditors. Now, there are two ways to go with this. You can set up a domestic asset protection trust, but you have to set it up in Nevada or Alaska, one of the other states. And because these trusts are only 20 or 25 years old, we don't have enough law that really tells us whether these asset protection trusts will work. If you live in California and you set up an asset protection trust, say in Nevada, and you put your assets in that Nevada trust, will a California judge really care what Nevada's laws are when you have a judgment creditor against you in California? And we just don't know that. So the other option you have is to set up a trust offshore. Now, offshore trusts are set up all the time. I set up my first one in 1989 because back in those days, we didn't have domestic asset protection trust law. But in those countries, you can set up a trust, that trust can hold your assets, and if there's a lawsuit against you and they come after the trust, the laws in those countries do not allow a personal creditor to invade the trust that's set up in that particular jurisdiction. And it's a pretty big effort and situation for those creditors to go to another country to try to penetrate that trust. So when you have an asset protection trust, and if you're threatened with a lawsuit, my job is to go to the other side and explain to them what you have in place and explain to them the difficulty they're going to have in being able to enforce that judgment and to see whether or not I can get you out of that lawsuit for pennies on a dollar. Lawyers don't want to sue people if they're not going to be able to recover. And that's why an asset protection trust for the assets you want to consume and have for the rest of your life needs to go into one of these buckets, because if you leave it in your current living trust, it's not going to protect you in the case of a lawsuit. This is how we typically structure. We'll have a trust, let's say, set up on the Cook Islands. And by the way, if you think the IRS cares that you have an offshore trust, that you're breaking the US tax law, the IRS wouldn't print all the forms that people would, for US taxpayers to file if going offshore were illegal. You just have to tell them about it. Using one of these trusts doesn't change your tax liability. Whatever tax liability you were paying the day before you set up the trust, you'll pay the same amount afterward. But it just makes it much more difficult, if not impossible, for somebody to reach those assets in a subsequent lawsuit. One of the most important assets you own is your personal residence. In California, we have an exemption, a homestead exemption statute that protects up to $699,000, $700,000 of your equity. But if you're living in one of these beautiful communities where you have millions of dollars of equity, in your home and you get sued, that house above $700,000 is vulnerable to a creditor. So what do you do about it? Well, you can set up what we call the HELP Trust, the Home Equity and Lifestyle Protection Trust. How's this work? We want to convert you from an owner to a tenant. Because if you're a tenant in that property and you get sued, your creditors can't take it from you. So how do we do that? Well, we form an LLC, what we call a disregarded entity. We put your personal residence or your vacation home into this LLC. We form a trust, an irrevocable trust in the state of Nevada, naming your spouse and your children as beneficiaries. We want to avoid reassessment under Prop 13. And you put that LLC interest into that trust. And then you rent the house from the LLC which you manage. So by doing this strategy and converting you from an owner to a tenant, if you're subsequently sued and they come after your house, you don't own that house any longer. You're simply a tenant, and that's going to, again, to drive the parties to the bargaining table and get that case settled for far less than would be the case if you continue to own your personal residence. Any questions on this? Yes, sir.
Can you do this if you still have a mortgage on the property?
Well, as long as Jim will let you do it. You have to get lender consent. Some of my clients like to ask for permission, and some want to ask for forgiveness. We recommend that you get the consent from your lender, and they generally will give you consent. But the security that the lender has is not impaired at all. If you don't make the payments, they're going to foreclose on the house. But you want to get their consent. Anyone else? Yes. If you have investment properties, you would want to put those properties into an irrevocable trust. And again, for your kids. Now, if you're managing the properties, as long as you are the manager, you get to control 100% of what goes on. Remember, think about this. You want to control your wealth, you just don't want to own it. If you own it, they can take it from you. And real estate is the most litigated asset class we have. So if you have a lot of real estate, put each property in a separate LLC. You can even put the LLCs in this trust, but if you're the manager, you get to control whether the property gets bought, gets purchased, gets financed. You're the boss, but you just don't own it. So you can, but this structure is designed for people who have expensive homes and expensive vacation homes, because there's nowhere else for you to put that that's going to protect that equity. Yes, sir.
The property is held in tenant in common.
Well, tenant in common is a problem. The question is what if the property is held in tenant in common? Tenant in common, basically, you have an undivided interest in the property. If you hold the property as tenant in common with another person, and that person gets into a lawsuit, and they file a judgment against that person, your co-tenant in common in the county, that judgment is going to lien the entire property. And if you try to finance it or sell it or what have you, it's going to interfere with your ability to do those things with that property. So tenant in common is probably one of the worst ways to own property. You want to put your properties into an LLC, be members with or partners with the other individual, and that way if you get into a lawsuit, they won't be able to interfere with the property or cloud the title. They'll simply only be able to go after your LLC interest. And LLC interest and partnership interest cause a lot of creditors, judgment creditors, headaches when they try to enforce the judgment against that. Okay. Way in the back.
What are the tax ramifications of setting something like that up?
What are the tax ramifications? Completely tax neutral. When you complete this transaction, you'll still pay the same, everything will flow down to your personal 1040, so it doesn't impair that. We can do this in a way that doesn't trigger Proposition 13, but what it will do is if you're in a lawsuit and the other side realizes that 5 years ago you set up this structure, they're not going to come after you because the cost to be able to attack that and most likely lose unless you somehow messed it up, they're not going to get the assets underlying the HELP Trust. Property tax is not reassessed if you do it correctly. Well, if you want to maintain the tax neutrality, then you would do it as a disregarded single-member LLC. You can move community property into it. You can move separate property. Depending upon how we set it up and the Prop 13 issues, we may need to convert it from community property to separate property. Now, I will tell you, if you do this, you will lose the income tax-free step-up in basis because you're putting the property into, you're putting the LLC into an irrevocable trust. But I'd rather see you be able to maintain the property away from potential creditor claims than to worry about the income tax-free step-up in basis, which they keep talking about repealing anyway. Now any more questions on this? Yeah.
You satisfy some of this with insurance or not?
Well, can you satisfy with insurance? The way I look at the insurance market, insurance companies cover you if you fall off the roof, but not when you hit the ground. So if you look at your umbrella policy, they're very inexpensive, but if you read the policy and the exclusions in that policy, you then begin to understand why they're so cheap. They don't really cover very much. And then when insurance companies begin to experience losses in particular areas, they move the goalpost. They either stop insuring it or they jack up the premiums. This way, if you have a $10 million, a $5 million, a $50 million residence, you can put it into the structure, and that property is not vulnerable to a judgment creditor claim if it happens in the future. Okay. Yeah.
Do these trusts, when you form them, do they need to be recorded?
When you form them, you would record the deed into the LLC. So it would be the ABC LLC. That gets recorded in the county. And then you take the LLC membership interest, which you got when you put the property into the LLC, and you transfer it into your trust. And then you no longer own the property. Your family are beneficiaries of the trust. You're the manager of the LLC, so you get to make all the decisions. But you're also a tenant. You enter into a rental agreement. Every 5 years you renew it. You pay fair market value rent. The rent is used to pay your mortgage, used to pay your property taxes, used to pay your CapEx expenditures.
I've always been surprised that none of the trusts that are created, whether it's family trusts or irrevocable, they don't need to be recorded. And I'm rather surprised. Is it because it gives more chance for a legal industry to do more work in the future?
Well, questions about recording. Why don't they record the trust? Well, you want to have your trust document, the dispositive provisions in your trust, you want to keep those confidential. So we provide a certificate of trust, so you just give the bare essentials to whoever needs to see it, but you don't want to record the entire trust. It's not necessary anymore. Yeah.
What happens if you have your property in corporation?
If you have a property in a corporation, you should probably fire your CPA. I hope he's not here. When you put property in a corporation, it creates double taxation. Taxation when you sell at the corporation level and taxation when you take it out. It was a commonly done thing before we had LLCs, but there are some tax planning strategies that you can consider to get it out of the corporation, but you don't want to own real estate in the corporation. And if you have any questions, if you do and you want to talk to me about how to fix that, give me a call. Yeah.
Do you think the gift tax exclusion is going to be eliminated or stay in place at about the same number? I guess what,
Great question. The gift tax and estate tax exclusion this year is the highest it's ever been, $13,990,060. At the end of this year, unless Congress gets together and they either extend or change the law, it's going to revert or sunset back to about half of that amount for 2026. If you're not making gifts to take advantage of the higher exclusion, and do I have no way of knowing what Congress will do. He can't even get all of his people, in his cabinet appointed without a lot of angst. So who knows whether they're going to pass the laws. But if you haven't utilized, it's $13,669,960 per spouse, per person. So I'm going to show you now the Have Your Cake and Eat It Too Trust, which is the perfect vehicle to transfer your assets, to remove your assets from your gross estate, so when you pass away, whatever those assets appreciate to are not going to be subject to that 40% tax for 365 years. Now, I'll take you back to the summer of 2010. Congress was debating with Obama whether they were going to extend the Bush tax cuts. And on December 17th, they finally got together. Obama signed the law, and then they increased the gift tax exemption and the estate tax exemption to $5 million. Now it's almost $14 million per person. So think about it. If you have the resources and you can transfer $14 million per spouse or $28 million out of your estate now, and you live another 30 or 40 years, and that property goes up 3x, 4x, 5x, the federal estate tax rate at 40% is avoided and can be avoided for 365 years if you pick the right state to have your trust set up, which is not California. The problem with making these large gifts, if you make this gift to the trust and then your kids marry the wrong spouse, They vote for the wrong president. They don't come visit you in the retirement home. Whatever the situation, or you get donor's remorse. People are reluctant to make gifts to trusts, particularly the traditional dynasty trust, because you may one day want to get that back. So thank goodness for a number of private letter rulings that came out of the government back in 2009, which enable us to set up a trust, a traditional dynasty trust, put your kids and grandkids and great-grandkids in the trust. But if down the road you get donor's remorse, or you want to be added back or you want to be added to the trust as a beneficiary, we have a mechanism that allows you to do that. Now, I have to tell you, I've never had a client in the 14 years I've been setting these high-set trusts up call me up and say, hey, I hate my kids, I want the assets back. But probably half of them wouldn't have done it if they didn't have the ability to do so. So we refer to this trust as a flexible gift trust. So you set the trust up, we use Nevada again as a state that they have a 365-year trust period. It's long, California's about 90 years. So if they find a way to bring you back, you're gonna have a nice portfolio of assets to tap into. But these, you can leave it in trust for multiple generations, but if you later need or want those assets back, there's a way to be able to do that. So you have the flexibility. The assets in the trust are protected from your kids' and grandkids' creditors. They're protected from divorce, protected from bankruptcy, IRS liens, civil lawsuits, which is really good. And if you have a large estate and your estate exceeds the $14 million I mentioned earlier, you can sell the assets to the trust, which is called an estate freeze, take back a promissory note, which never grows in value, and those assets over $14 million wind up in your trust and grow outside your estate. So by the time you and your wife pass away, there is zero estate tax on what's in that trust, but you have the flexibility. Now, what a lot of my clients have done, they've put income-producing assets, their businesses, their real estate into this trust because they don't need the money. And what they'll often do is they'll buy a life insurance, the trustee will buy a life insurance policy on the life of the grantor. So we create a second and use the cash in the trust to pay the premiums. So when you pass away, not only are the assets that you gave to the trust initially in the trust, but now you get this large life insurance policy that pays off into the trust so that your kids and your grandkids and your great-grandkids will have a much higher ability to have distributions coming out of the trust from that life insurance policy, which is income and estate tax-free. So it's a wonderful financial model, financial tool to be able to do both estate tax planning, take advantage of the $14 million per person exemption before it drops, if it does drop, and then you can do some financial engineering and protect the assets from your creditors. Yes?
How do you feel about placing LLC inside IRA? Now the trust.
Question is, how do I feel about putting an LLC inside of an IRA? I think it's a great strategy, but you have to make sure that if the LLC has non-marketable securities, if it's investing in businesses, you wind up having what's called UBTI, unrelated taxable business income. And if you have that, it generates like a 37% excise tax to the owner. So it's make sure you've considered all the. If you have securities in your LLC, you probably don't need the LLC. Just put the LLC in your. Put the securities in your IRA. Yeah.
Going back to the health trust, you basically become your tenant.
You become a tenant of the LLC, not your tenant. So you're the manager, but you're not the owner. You're a tenant.
So if you, let's say, right now, if I wanted to sell my home and not have to pay capital gains on it, I could transfer like into a 1031 Delaware trust or something like that. I have to rent my home for a year. Does this count as renting it?
If you moved out of the house and you rent, and the LLC rents it to a third-party tenant for the prescribed period of time, we like to see it at least 2 tax years.
It has to be done to a third party.
Yeah, it can't be rented to yourself. And then you can do a 1031 exchange because you converted it from a personal residence to a rental property. Yeah.
Question about the potential grantor trust.
Yes.
Assume community property, husband and wife, put appreciate the assets and all those as expected, they live for a long time. Then there's the first to die. Now, once it's in the interest, it remains taxable to the grantor.
Right.
As the main right. When the first to die occurs,
Boy, that's a complex question. The gentleman's asking if you have one of these trusts and it's community property, the first spouse dies, does the trust become a non-grantor trust? What happens in a case like that, and I'm happy to speak to you afterwards because this is probably, most people are never going to need that. One of the trusts becomes a non-grantor and the surviving spouse's trust remains a grantor trust. I thought you were going to ask me, do you lose the step up in basis? Yeah. Well, it's a way around that. These trusts have swap provision, and the surviving spouse can swap assets for other assets and have a higher basis. But again, that's a topic. Sure. Sure, absolutely. Anyway, I just want to quickly wrap it up. I've written a book, Ladies, Estate Planning for Women Only, No Men Allowed. I used to lecture on cruise ships for 30 years doing this topic for the women because I didn't want their husbands in the room. I left a couple of the books out here if you want to grab them, or you can order on Amazon. It's a wonderful primer for the ladies to learn about the basics and even up to the more advanced planning strategies. We have a newsletter if you want to sign up for that. It's free. I write about these topics all the time. I have 26 articles on Kiplinger you can pull off my website or the internet. And I want to thank you for having me. And I'll stick around for a little while. I've got a call. I've got to get on at 12:30, but I'll be here until then and answer any questions at the break.
Thank you very much, Jeff. I have the cake and eat it too trust that Jeff set up for me. But if you have questions about this type of stuff, and you never know when you're going to get blindsided by, an ambulance chaser of some sort that is coming to get your assets. And when you do, you want to make sure that you had Jeff or someone like him protect your assets.